Right, so this question is all about juries. We've looked at magistrates already. These are also known as lay people because juries are not paid. Normally what would happen is when you get picked for jury service, you'll be able to claim some form of expenses, and a lot of places will still give you your full wage, but that is up to the discretion of the employer. Looking at juries then, they obviously play an important role and they are used in the 4 different courts you can see there below. So the Crown Court is a major use of juries. That's probably where you've heard of it the most in your criminal cases. Juries can also sit in the High Court and listen to civil cases. They can also sit in the county court and listen to civil cases, and finally they can sit in the Coroners Court, and Coroners is all about any form of suspicious deaths and who will be liable and to pay some form of compensation or some fees there to anybody. So the Coroners Court will have some involvement with jurors. If you get this question, then it's an 18-mark question and it wants to know what roles juries have in criminal cases and civil cases. Now, there's no really easy way of remembering this, to be fair. If you can think of your own little acronym, then feel free to do so. But other than sort of like numbers and key words, there isn't really anything else that we'd need to discuss. Right, so first of all then, in a criminal case, we have 12 members of a jury. Right, they sit in the Crown Court and they deal with less than 1% of cases. Now, just to explain how we've got to that figure then, so you don't just think that we can't do maths. 97% of criminal cases are dealt with by the magistrates, the vast majority being somewhere in low-level tribal either way, so the magistrates deal with them. The other 3% then get dealt with at the Crown Court. Out of that 3%, 2 people will plead guilty. If you are pleading guilty, you don't need a jury. Hence why juries only actually deal with 1% of cases. So even though you hear about things in the news, like serious murders, robberies, rape, etc., in actual fact, they're only dealing with 1% of our criminal cases. It's the magistrates that hear with the vast majority. Juries normally sit for a 2-week period. It depends on the case. Sometimes it's less, sometimes it's more. It just depends, obviously, on the facts of the case, what's going on, what evidence we need, how long it takes for witnesses to arrive. So you go on the average of 10 working days, which is 2 weeks. They listen to evidence from the prosecution, from the defence, and they listen to the judge summing up. So your job is to listen to all the evidence that's being told to you or shown to you, and you decide whether the defendant is guilty or not guilty. So that is your job as a juror, to decide guilt. Are they guilty? Are they not guilty? Unless the judge says that you need to acquit, in which case then you have to. You can't decide guilt, you just need to acquit. It's their responsibility to make decisions based on fact and not law. Right, so what we mean by this is that the decision that you're making is based upon what you see in the courtroom and not any law that you might be aware of. So for me, for example, because I'm a law teacher, I have some knowledge on aspects of law, I can't use that when deciding that case. So if it's a murder case and that defendant's then going to start pleading that they're schizophrenic and they've got some form of mental condition, I can't then use my law on insanity, my knowledge that I know on insanity, to be able to apply to that case. I've just got to use the facts that are shown in front of me. They deliberate in secret, so this just means that anything that happens with the jurors, they discuss it in secret. So they don't talk about it in the courtroom. What they do have to do is, once the evidence has been told, the jury have to go away into a jury room and they discuss in secret what their verdict is going to be. So anything that gets said in the jury room has to stay private. If they disclose anything, it is in fact a criminal offence and they can be convicted for that. Okay, so you've got to make sure that anything that you talk about in the jury room, you do not mention to anybody else. Second to last then, most verdicts are decided on a unanimous basis. Just adding a note there then, unanimous means that all of the jurors agree. All 12 say, yeah, he's guilty, evidence is there, DNA matches, it's pretty obvious that he's guilty looking at what is said in court, we're going down that route. Now, to be fair, the judge prefers a unanimous verdict, but in hindsight, there's not really many that will get produced. It's hard sometimes for a jury to all come up with that same verdict. So even though unanimous is ideal, it's not something we end up having on a regular basis. So what we do allow is a majority verdict. So we can have 10-2 or 11-1. So 10 juries say one thing and 2 say the opposite, or 11-1. Now this was to stop jury nobbling. Now jury nobbling is where you will either bribe or you'll threaten the jury. So you'll try to get them to come to a particular verdict. If that occurred, obviously all 12 would agree on the same thing, so we'd be a bit suspicious. So to stop that from happening, to stop them from threatening each other or bribing or anybody on the outside doing the same, we allow majority verdicts to take place. So you don't have to have all 12 agreeing. So that just means that the 2 people that might say not guilty don't then end up getting threatened by somebody else to go with the guilty verdict if they truly believe that they're not guilty. So that's why we've got the majority there. Lastly then, they don't give reasons for their decisions. So juries don't turn around and say we've gone for guilty, because the jury foreman will just stand up and say we've decided that the defendant is guilty of this charge. That is all you need to say. We don't ask you to say why. Probably more so because remember you have to discuss things in secret, and then if the reason you've come up with your verdict is wrong, we'd have to have a whole new trial, or if the way that you've come to your verdict isn't right. So what we do instead, we sort of play dumb, and we say no, we don't want you to tell us how you've come up with that decision, we just want you to tell us it. Okay, now that's the role of juries in a criminal case, i.e. things involving murder, crime, something that results in prison. Now, as you can see, there's no way of making a word up from that, but you just need to get down the side here, just get some form of keywords or something added at the side. So it might be that you just use the number 12 for this one, 2 weeks for this one, evidence, guilty not guilty, fact not law, discussing secret, unanimous, or reasons. You just need something that's going to help you remember that phrase, because you do need to write this as a big paragraph in the exam, so it needs to be pretty detailed. Alright, so that's the criminal side. When we look at juries in a civil case then, there's a few things that we need to talk about here. Right, so first of all, we don't use them very often. In reality, it's probably less than about 10 cases a year that we use jurors. Now, if they're in the High Court, we use 12. So the High Court is at the same level as the Crown Court, but on the civil side. So we use 12 juries there, and if we go to the County Court, we use 8 juries. Okay, so you'll have 12 or 8. Now, in a civil case, juries are only required for 4 types of cases: defamation, false imprisonment, malicious prosecution and fraud. The main being defamation, slander. You're slandering somebody. So if you're saying negative things about somebody else, you're slandering them across the newspapers, across social media, they can then obviously sue you, and we will use juries in that sort of case. False imprisonment, so the fact you've been put in prison when you shouldn't have been. Malicious prosecution, so the way that they've prosecuted you is not right. Or finally, a big fraud case. So we will use juries, but only in those 4 types. The reason we do it is because those cases involve character or reputation. So obviously your reputation as a person is being hit massively through slander, through the fact you've been put in prison when you shouldn't have been, or the way you've been prosecuted, or a massive fraud case that maybe suggesting that it's down to you. So because it's involving character or reputation, we'll allow juries to be used in those cases, but only those 4. If they are too complex, we will still say no. So even if it's a fraud case, if it's far too complex with everything that's gone on, we will still say to a jury, look, we don't need you. The judge will listen to it himself. Just for the simple fact that it's very, very confusing. We don't want you to get it wrong. It's important. So what we'll do instead is the judge will turn around and he'll say, right, we don't need a jury. I'm going to make that decision because obviously it's too complex. Right, turning over then. So originally you could apply for a jury to sit on other cases. So personal injury, when that first started to crop up in the courts, we allowed members of the jury to sit and listen to personal injury cases. But it would only be exceptional circumstances, because personal injury is obviously something, you've had an accident at work, yada yada yada. We wanted to make sure that it was right. So we would have juries, but only in exceptional circumstances, because at that point, not a lot of personal injury cases were occurring. But when we had the case of Ward versus James, what we did is we decided that we're not going to use juries for personal injury cases anymore, because it isn't exceptional. You've seen it on the TV. We're in sort of a blame situation now. Our society is talking about where's a blame, there's a claim. So we've got too many people going for personal injury claims now. So what we do instead is we say, no, they're not exceptional cases. It's happening too often. So what we're going to do is stop using juries in that sort of case. We'll just decide it in court. If you are on a civil case, you've got 2 jobs. So thinking back to criminal, your only job is to decide if the defendant is guilty or not. In a civil case, you've got 2 things you need to do. Decide who's liable, so not guilty, liable, and how much damages need to be paid. So who is liable for whatever's gone on, and how much money are you going to make them pay? So when we had the big battle between Samsung and Apple, they would decide who of the 2 was liable. Well, in actual fact, they're both liable for different things, but who was liable, and then how much money each company had to pay each other. So that's a big job for you as a jury, because you've got the ability to set any sort of damages that need to be given. Your last relevant bullet point then, in civil cases, juries can actually sit in a coroner's court. Okay, now it looks into suspicious deaths, so yeah, prison, industrial accidents, police cells, maybe anything where they could have the health and safety of the public could be at risk as well. We'll look into the death, see why it's suspicious, see what's gone on, and the jury will make a decision there as to what needs to happen. So if it's in a prison, do we need better standards in prison cells or police cells? Do we need better qualifications of those working on building sites? What do we need to do to try and stop that happening again? Okay, so that's your role question. So role of juries in a criminal case and a civil. It's worth 18 marks, and you need to include all your bullet points to get the credit there. Okay, do it as 2 separate paragraphs. You can't write it as a bullet point. You can do a plan like that, but you have to physically write it as 2 big paragraphs. So criminal, underline it, write a paragraph. Civil, underline it, write a paragraph.